we don't have local government, is that in small communities, it's very difficult for people to quarrel with their neighbors about things like this. So it is good to have a third party involved in the process, right? My difficulty with what is being proposed here is that it is a bit archaic. And I also mentioned, I think in my submissions to you, written submissions, that what it is showing up is a tremendous gap in environmental management law in Barbados. As is the case with your medical law, which I think is scattered about the statute books in various places. For example, I noticed that senior citizens' homes is under regulations under the Health Services Act, but children's daycare centers is under the Children's Act and so on. So you have to really go through the statute books to find what the law is in Barbados on related subjects, if I could call it that. So the thing is that I think that though we have elements of environmental law in Barbados, we don't really have a proper framework of integrated environmental law. And one of the reasons is that we have never, let me put it this way, the degradation of the environment by agriculture since the 1600s has removed most of our natural cover, most of our bird life, and all that sort of thing has gone many, many decades ago. Hundreds of years, actually, has been involved in that process. So really, some of the critical issues in Barbados in terms of the environment don't face people on a daily basis. We do have a flood protection act. Flooding is an issue, and groundwater is an issue, and we have a very old groundwater protection act that never has a protected area been declared under that. I see a new scheme of groundwater protection being proposed. It's mentioned in the new physical development plan that was approved by Parliament and gazetted on the 31st of December last year. But groundwater protection would, I think, be a critical issue for us in Barbados, and it's a critical health issue. And in fact, how we've been doing it over the years is through development control, in which the public health authorities have played a role being in charge of the disposal of waste under the regulations made under the Act. But so that's an important issue. And of course, some of our important issues are to do with the marine environment, very much so. And now we have the whole blue economy and what have you. And there is a piece of legislation to which regulations have never been made, protecting the environment in the marine area. But how it's defined, it actually captures a lot of things on land, because once they end up, it's sort of a ridge to reef concept of the environment that is captured there. But you still have this sort of a very scattershot approach. And as I mentioned, I think in my submissions here, we have something now called the Environmental Protection Department, but they don't have a proper piece of legislation vesting them with their jurisdiction. What they are doing at present is, because they were actually the Health Engineering Department that was taken and morphed over into the Environmental Protection Department, they are still operating generally under the Health Services Act. And that, to me, is something that, well, I say to you, I wouldn't publicize it out there for every lawyer to hear, but I don't think that they have proper legal jurisdiction under the Health Services Act, because only people that are working under the Minister of Health, and that EPD is now in another ministry. So for a couple of years now, I have been flagging this as an issue, because believe me, if I was the defense lawyer, right, and EPD was trying to come for my clients, I would go straight to court and say they have no jurisdiction, right? But so I think that is something we need to clean up, and certainly I think we need to clean up the statute books when it comes to a number of things like air pollution. I think I mentioned noise, odors, and other things like that that were omitted here. So basically, I have no intrinsic objection, of course, to upscaling the Health Services Act, and I think it needs more radical revision than is suggested here, on certainly modernizing the nuisance regulations, but I don't think we've modernized them here. I think the language is still archaic, and some of the terms you've tried to define, or let me put it as the drafters of these amendments have tried to define are really Victorian in their nature. So that's basically what I would like to say to the committee, and I would be happy if you have time and you wish to ask me any questions, I would be happy to respond.
Thank you very much. Ladies and gentlemen, I'm going to open the floor. If there are any questions, comments, CPC, we've heard that the legislation may be archaic in its approach. Do you have any response to that in particular?
Good morning. I listened to Ms. Alahar's presentation. It was quite interesting. In relation to the assertion that the legislation is archaic, it's important to remember that the bill is an amending bill and not a new act. So in light of that, when we are drafting, we generally don't use new terminology to mix in a bill that has existing old terminology. So for the sake of consistency, that's why the legislative language is the way that it is. And it's also important to remember that since this isn't a new act and there are also going to be other amendments to the Health Services Act, which are currently being undertaken, that it was important that the legislative approach be consistent and those were in keeping with our instructions.
Thank you very much. Anyone else with any other comments? PBD? No? Yes? Ms. Sandhouse, go ahead.
Thank you. In response to Ms. Toppin Alahar's presentation, I would say that we in the Ministry of Environment, we do agree that there is a need for environmental legislation. To that end, we have already recently drafted a terms of reference. We're looking to engage someone to prepare draft legislation for us, hopefully within this financial year, to address that particular issue.
Thank you very much.
Mr. Chair.
So just a bit of housekeeping, so to speak. Whenever we're going to speak for the very first time, please identify yourself and the organization. All right, thank you. All right, so.
Mr. Chair.
There's a question from MP Prescott. Go right ahead, please.
Yeah, thank you very much, sir. And good morning to the entire collective. For a long time, I was extremely cautious and critical.
Could you raise
about the EPs?
Excuse me. Could you raise the volume on your device, please?
Ren, I get some problems with this thing. Yeah.
That's fine. It's good.
You're better now?
Better.
Yeah. For a long time, I've been getting some challenges in understanding how when the Environmental Development Department is taking steps to address issues like the removal of derelict buildings, derelict vehicles, and so on, the Environmental Department within the Ministry of Environment was claiming that they're using the provisions within the Health Act in order to give notice to persons who were the purported owners of these vehicles and these houses. And in my layman understanding of the law, I could not really grasp all the logic that I was hearing coming from the highest levels of government, that there was nothing wrong with the Environmental Department and the Ministry of Environment using the provisions within the Ministry of Health to stick notices on the various vehicles across Barbados. On more than one occasion, I don't know exactly what were the arguments advanced within the court of law, but on more than one occasion when vehicles were moved, some owners lay claims to that the vehicles were in a good state, and one of the challenges that the officers always had is most of the time these people were awarded damages for the removal of the vehicle by the Ministry of the Environment. And I always contend that the Ministry of the Environment really needs a provision in the law related to that ministry itself that will give it the legitimacy to do what they were doing, and that it was wrong to be using any provision or trying to apply any provision under the Health Act. And I believe that in the presentation, Judge Harris or consultant Harris was indicating that that is a major contradiction within the law itself. And I would love to hear greater clarity on that, and to know if such a thing would be addressed in the new amendments to this legislation.
Thank you very much. I'm going to ask Mr. Ronald Chapman, the Acting Chief Environmental Health Officer, if he has any comments to make on what has just been said.
Ronald Chapman, Acting Chief Environmental Health Officer. I think we've established over the years the nuances where the EPD and the health legislation is concerned. I think that we have tried to address that issue with respect to a memorandum of understanding. And that memorandum of understanding, once it has been worked out, would allow then for the EPD until such time that it has rectified its issues to continue to operate under the Health Services Act, because I need to be guided by a lawyer on this one, but I think section either 9 or 12 of the legislation basically says that the Minister of Health may assign or authorize any person or agency or so on to act on behalf of the Ministry of Health. So until such time that the additional legislation, I think the MOU would be able to address those issues.
Thank you very much. Anyone on the floor?
So let me seek some clarity on this. So the MOU has greater legal status than the statutory provisions?
No,
So
sir.
if there's a law, can the officers or the minister or even any senior officer arrange an MOU between his ministry and another ministry that gives guidance to how this particular provision can be applied? If I understand the principles of law well, the statutory law must be of a highest legal status than the memorandum of understanding. The memorandum of understanding depends on what is stated within the law itself, and not can be seen as a document alienated totally from what the law stipulates.
Ms. Alahar, you.
Yes, thank you. I think what Mr. Chapman is referring to, there are two sections in the Health Services Act that enable the minister to make certain appointments until delegation, powers of delegation. Also, Section 9 is the principal one. But With the read section 9, clearly it doesn't seem to me to enable the minister to go outside the ministry even to a strange, what I would call a stranger-in-law. I think that the minister, this minister I can't see behind me.
Mr. Prescott.
Yes. What he's alluding to, I think what Mr. Chapman is trying to say is if you find a section in the act that allows the minister to grant that power over, then you use the memorandum of understanding under that section. So therefore it falls within the scheme of the act. I'm not sure that the section enables that to be done, but that's not for me to say, it's for the Attorney General to advise on. But I think that what will have to be done in due course, and I know Ms. Senhauser, because we have collaborated before on a consultancy that I did for an international organization. I think what will have to be done, or what is usually, I'm going to say, what is usually done, and I would defer to parliamentary counsel there on that, is that when you bring the new legislation in, you have a retrospective validation clause in it that will clean up past things if they were done without the correct measures being in place. So there's a solution there, but what is really needed is proper legislation for the EPD.
Thank you very much. CPC?
Shaquille Newton, Parliamentary Counsel, Acting Office of the Chief Parliamentary Counsel. So it does appear that there is somewhat of a discrepancy within the legislation, but I can draw your attention to the Interpretation Act of Barbados, which generally governs the use of the word minister. It is normal in the course of things not to define the term minister so that these matters can be worked out administratively. What has happened here is that minister has indeed been defined to mean Minister of Health. I can write a more fulsome opinion on this matter in due course, but a solution that is possible right now could be the removal of the specificity to the reference of the minister in the legislation, and that the Interpretation Act then can govern the term minister, and that should provide it will provide a solution to allow for these matters to be worked out administratively for the time being.
Thank you. Any further comments? Senator Rogers?
Thank you very much, Chair. I would just like to thank Mrs. Toppin-Allihar for her presentation and flagging the importance of bringing our environmental protection legislation into the 21st century. Having sat on the Constitution Reform Commission, I can tell you that this took up a lot of our time because we recognized it as one of the areas that we really needed to pay close attention to. So hopefully when those documents are presented, I do know that there was a lot of time spent on expanding environmental rights and so on. And so hopefully that will guide us in terms of our new legislation on the environment. So I just thought I'd thank you for that.
Thank you. All right. I wanted to ask EPD in particular to shed some light on what it is that you actually do, because we have persons who will be watching sometimes from outside, and when they hear these terms, they have no concept of what you do, what we're actually talking about, and that's especially as it relates to Mr. Dean and the Chief Buildings Development Officer. So I would kindly ask you to give us, some background on what you do and how do you see yourselves fitting into this entire discussion that we're having on this particular bill.
Good morning, Andrew Dean, Acting Chief Buildings Development Officer, Environment Protection Department. Initially, back in 1971, when the department was first established as the Environmental Engineering Department in the Ministry of Health, the functions were that of building development control and water quality monitoring. The department expanded subsequently, years after, and expanded the water quality monitoring program, the solid waste management, the air quality, both ambient and indoor, but subsequently removed indoor air quality from our mandate, as well as the marine pollution control, noise monitoring, and derelict vehicles and buildings. Those are the main functions. I think and we used to do swimming pools as well. That was returned to the Ministry of Health. With the 2019 legislation of the Town Planning Act, the building development component of the department was shifted to the Director of the Planning Department. So the Health Services Building Regulations is now deemed under the Planning and Development Department. The derelict program, which include derelict buildings and things, which you did rightly mention, and Mr. Chapman also acknowledged, is a function of the Ministry of Health, but the EPD carried out that function, has been carrying out that function since 1986. MP Prescott also alluded to that it may not appear to be legally correct, which I must acknowledge, but we have been carrying out this function for all these years, all right, and have not been challenged thus far. So I think I've answered your question.
Thank you very much. You can come in if you wanted to.
Yes, I just wanted to say that, you know, I think everybody's doing their best, even with the deficiencies in the legislation. And I've seen that, for example, EPD has been helpful in the planning process in crafting conditions of planning approval, even for things like noise pollution, using WHO standards and so on. But we have no standards in the domestic law. So I think that we shouldn't be coming in through side windows and side doors to attack this sort of issues in this modern age. We need to clean up the statute books, get things right, and put things in the right place. Thank you.
Thank you very much. Now, I can't help myself sometimes. But when we look at this particular issue, the question I think that one has to ask is, how did we get here? And why are we here to deal with this particular problem? Because one of the things that you keep hearing people talking about is the whole idea of penalties. And it seems harsh, and those are a couple of the comments that we have coming in. But this is really a challenge of a changing culture, which people, for some unknown reason, do not want to identify with. Laws are not made or put in place because people are doing the things that they're supposed to be doing. You find laws coming in, more and more laws coming in, as a society falls, basically, ethically, in all different departments. So it is important that people understand, to me, how we've gotten here and why we are here, what is the public mischief or nuisance, so to speak, that you're trying to address whilst doing this. And I totally understand the deficiencies within the laws and the other things that we need to clean up. But I think, again, focus for me must always be on why are we here? What led us to be at this particular point in time to deal with these particular issues? So I want to thank everyone so far for their contributions. If there's anything else that anyone would want to, Ms. Alahar, put on the table.
Yes, Mr. Chairman, thank you. I think one of the key things in this legislation, I think I mentioned it in my comments, is that they're trying to change the enforcement mechanism to get to your point. by using the administrative orders in place of summary prosecutions, prosecutions for summary offenses. And certainly the prosecutions for summary offenses, one reason that people have been able to break the law almost with impunity throughout the Caribbean is because it is so very difficult for a number of reasons. One being the magistrates court system is really so backed up in most of the countries. You know, actually having to go through the process of collection of the evidence and you know, going through the criminal process means, you know, the standard of proof beyond a reasonable doubt, et cetera, et cetera. So that people have been looking for alternatives for enforcement mechanisms, and I've seen these administrative notice type enforcement elsewhere. For example, I was recently doing some work on maritime law in Anguilla, and they have administrative notices. Most of the time when people use these administrative penalty notices, the provision is if you don't pay, then the state has to collect it as a debt in the civil realm of the courts, petty civil courts, if you could call them that. But there is also an alternative which we actually put in the new Planning Act, the equivalent of giving people tickets, right? So it's a fixed penalty notice, it's called in the new Planning Act. So we could think about that, giving people a fixed penalty notice, which then is like a traffic ticket, right? Which is even a different thing. Because here, the remedy is that if you've got this administrative thing and you don't pay it, instead of having to go to the magistrate's court, it's going to be put on your land tax bill, right? Which seems to me a very circuitous and burdensome thing. And then it raises the issues about the appeal and under what piece of legislation you're going to appeal. Are you going to appeal under this, the Health Services Act, or are you going to appeal under the Land Tax Act and so on, and get yourself into a thicket of difficulties there. So I think that there are the three options really that I'm familiar with. There may be more. Of course, there's always the indictable offense, but for serious, you know, where something is done with malice aforethought and so on. But there is the conventional summary offense. There is the new or relatively new administrative penalty notices, and there is the fixed penalty notice or traffic ticket for environmental offenses that can also be used. So I think there's a range of things, and I think the desire here, and it's a commendable one, is to avoid having to prosecute these matters in the magistrate's court. And that is the aim, I think, the basic underlying aim of what you have before you. But it's a matter for you as to which device you think will work best in Barbados and have the least blowback. I imagine that you're going to get a lot of blowback if you put it on people's land tax bills. That's my feeling. Thank you.
Thank you very much. Any further comments?
Good morning, everyone.
Ms. Ford?
I just want to indicate that I've really got much clarity now, because the biggest problem that we, the regular citizens, have is calling the department and then say, it's no longer us now, it is town planning. And it becomes extremely frustrating. And unfortunately, Barbadians generally have become extremely indifferent and disrespectful when it comes to laws and doing things. And it is really creating a serious situation in almost every community across Barbados. And I believe that what we are doing here today and the information that we are gathering now will help to make a tremendous change in what we do. Because for me to call the Environmental Protection Department, if that is what it's still called, and then I'm told, no, it's the Ministry of Health. Or you don't have to go out on planning in relation to all these household appliances that are lined up alongside the road taking up space, or a derelict house that really needs to be demolished to save people from getting injured and all that. And therefore, if it is causing me confusion, what about the general public? And therefore, where in this then can we get to be able to focus on public education and using the government information service more readily to be able to educate the public as well? Because to read the laws, I'm a total fool. There are so many things I do not understand. And to me, it's not about education alone, but it is to do with, that is your field of endeavor as an attorney at law and so on. And therefore, you understand it better because you do it every day. But for a regular citizen like me, in that respect, I cannot even advise anybody in the community where I live because I read, but still I cannot internalize it because I have no interest in that way as an attorney would, because they will have to defend and so on and so forth. So whatever we are doing here, I am going to call at this point for us to have more public education, and rather than the calling programs and so dealing with this political thing, and that, let us get into the meat of the matter so Barbadians better understand. You don't just pick up the phone or call or go to an office, especially senior citizens, because you know I'm the oldest person here. And I have difficulty understanding a lot of things as a result. And therefore we need to really use the fora that are available to us to touch people and let them know. Because to take a bus and go to the Ministry of Health and then you hear, no, you have to go to another department, something else, and all the segmentation of the agencies, to my mind, that is helping to create confusion, and we're not getting answers to our issues in the communities where we live because of the transfer of this to that ministry and the other and so, and it's creating a lot of problems. And I just thought we would at that point.
Thank you very much. I'm going to go to Minister Tony Moore, who is online, but she needs clarification on something that was said. So over to you, Ms. Moore.
All right, I hope that the background noise is not a constraint, but I want to thank the attorney for the presentation and the clarification that she sought to offer through her presentation. I know that there was a concern that there was going to be blowback from applying penalties or to the land tax bill. And I missed a part of it. So I'm wondering if there was a suggestion. I know that the mention of a ticket was made similar to what was done with the Tongue and Country planning legislation. Is that the suggestion as an alternative to putting the payments on the land tax bills? Is that the clearer alternative being presented to the committee?
I believe it's been put forward as an alternative, but as was stated earlier, that would be for the powers that be to determine which way they're going to go. But I will let Ms. Alahar just go through it one more time so for your clarity.
Yes, I was just pointing out that there were three main alternatives for the enforcement of the law. I would be happy if people could come up with even a fourth, because we have so much problems enforcing this type of law in the Caribbean. But I'm not recommending one above the other to the committee because I haven't really studied how any of them, as far as I know, we haven't issued any new tickets under the new Planning and Development Act because the regulations for that part of the act have not yet been written. So, but it does exist, for example, under the Litter Act in Trinidad and Tobago and St. Lucia, where they do the derelict vehicles under their Litter Act, actually in those two countries. So there are possibilities. There are possibilities elsewhere in the region that you could also look at.
I thank you, because the suggestion therefore would be that if the application of the penalties on the land tax bill is something that's enforced and it does not work, then there are alternatives that can be considered, but in not submitting one above the other is not to say that it shouldn't be done. Thank you.
CPC.
Good morning once more. I just wanted to advise in relation to setting up the administrative penalty. Yes, the fixed penalty notices, as was done under the Planning and Development Act, was considered and could be used as a mechanism. but it was felt that the administrative penalty was more applicable in these circumstances. I first want to make the point that the administrative penalty notice does not automatically kick in. There is the provision for the contravention notice at Regulation 8. So it was felt that given this mechanism, it gave persons an opportunity to actually remedy the breach first. In relation to the point about the imposition of the administrative penalty when it remains unpaid on land tax bills, we felt that this was the best approach because in relation to these matters of public health and keeping your properties clean, these are all things which have a natural nexus with the land tax. So that is where this approach was taken. Not saying that the fixed penalty notice cannot work, but it was felt that the administrative penalty was more applicable in these circumstances. And also, Ms. Alahars, we're speaking the same language as drafters. For consistency of the statute book, this tends to be the approach now that we're going with in terms of sanctions and enforcements if you're making alternatives to penal sanctions.
Thank you. Any other comments? No? Okay, so at this time, I'd like to thank you very, very much, Ms. Alahar, for a very enlightening morning so far. And we look forward to maybe chatting with you a little further down as we get closer to bringing this particular session to an end. So thank you very much on behalf of the entire committee. Thank you.
You're welcome, Mr. Chairman. It's my duty as a citizen.
Appreciate it. So we're just giving 5 minutes before our next speakers. We have Mr. Anderson Cherry, who is online, but we're just waiting for one more person from the U.S. Haulers Association, and once he comes, we will get started. If we see it gets to 11. Okay, so we can start with Mr. Cherry, who is online, and we could then move on when Mr. Thing comes in. All right, cool. All right, so let's go to the line. Please bring in Mr. Anderson Cherry, and welcome.
Good morning, everyone. Thank you for inviting me.
Good morning, Mr. Cherry. Are you there?
Good morning, Mr. Cherry.
There you are.
Yes, sir. I'm here. Good morning.
Good morning, sir. How are you?
I'm pretty good, thank you. Yourself?
Okay, I'm well. Could you adjust the volume on your end just a little bit, turn it up a bit? Or if our technical team are able to do that?
Is it better?
That's better. So you can, just for the record, state your name and the association that you represent. Thank you.
Anderson Cherry, and I'm representing the U.S. Haulers Group.
Yeah. So it's Mr. Anderson Cherry, for those who probably missed it, and it's the Waste Haulers Association. We're still gonna need some more volume.
Is it better there?
Could you get a little closer to your microphone?
Up top.
That's
Okay.
a bit better.
Okay, thank you.
Good. All right ahead, thank you. Over to you, Mr. Cherry. You can make your submission. You can make your submission. Are you hearing me?
I'm still getting a little technical problem. If you do want some.
We're also waiting on the arrival of Mr. Michael Ford, who is also part of the Waste Haulers Association. I'd like to welcome the Honorable Davison Ishmael, Minister of State in the Ministry of Health and Wellness, who is joining us. Thank you so much, sir, for being with us. Mr. Cherry, are you ready to go? Ready?
Can someone?
We can hear you. We can hear you pretty well. We can ask the technical team to see if there's anything that they can do on their end to help. So we'll just pause until we can get that particular problem solved. We're also waiting on Mr. Michael Ford, who was supposed to be here in person, and we probably will have, if possible, Mr. Trevor Manning, who would also be a representative of the Waste Haulers Association. As was mentioned earlier, this issue really comes about because there is, and has been for a long time, complaints about, I guess, the falling health standards or practices within Barbados. And I think sometimes we can gloss over these problems because they don't seem large at a particular point in time. But most of us growing up in, especially those of us who've grown up in rural Barbados, would know that there was a time when you could not have anything like grass or anything like that on the premises. For those who are a little bit young and might not understand what it means to be out in the hot sun with a scraper or a hoe and having to make sure that there's no grass around the house. These were the practices which were, I would say, based on an old Barbadian saying that says cleanliness was next to godliness. And these are things that people in my age group and above would have grown up with. And it is really, it's not annoying, but it is, in my mind, it's a little bit strange that we've strayed away from what would have been basic ways of behavior as a people into what we find today that forces us to be in these sort of meetings, to create this kind of legislation to deal with a problem, which is really, when you get to the root of it, a very individual responsibility, if I will use that word, that people used to take seriously in the past. And I'm hoping that Mr. Cherry would be able to come in, because the West Haulers Association, if, as was mentioned by Minister Ford earlier, we listen to call-in programs. These particular organizations are ones who have a lot of comments made about them and how they function by the general public, and these are the matters that we as a committee need to be able to help to clarify in the areas where there may be error on the part of the general public, or basically to try to understand what may be some of the problems that faces the particular associations and others within the community. So I'm going to try to see if Mr. Cherry is ready, sir. All right. What I would like to do is I would personally like to ask a few questions whilst we're waiting for him to come in. And I'm going to pose this particular one to Environmental Protection Department. In terms of dealing with buildings in particular, could you give us some basic understanding of what is it that will cause you to have to come out to deal with buildings in that manner, and what are the things that you're looking for, and what are the things that you could at least enlighten the public about, so that they could probably prevent themselves from letting buildings get to that particular point where you have to step in.
You're referring to derelict buildings?
Derelict buildings.
Lisa Senhouse, Environmental Protection Department, Acting Deputy Director. With respect to the derelict buildings, the concern with the derelict buildings is that they're posing a risk, a public health risk. There are a number of criteria that we look at in determining if a building is derelict. A few of them are if it's a breeding ground for vermin. Another one is the structural integrity of the building. So the Health Services Act lays out a process for the government to deal with the buildings if they're posing a risk, a health risk. So under the Act, you have to serve a notice to the owner. You publish it in the newspaper, which gives the owner the opportunity to remedy the situation themselves. If that does not occur, the government can go ahead and demolish the building. And one of the things that is written into the Act is if government does demolish the building, that is considered a debt to government. The owner owes that debt to the government. So that's basically it, the process in a nutshell.
Thank you very much. where does, as a person who's actively involved with the preservation of, let me say, historic buildings, how would you deal with an issue such as one where, and this is hypothetically speaking now, you have a building that probably belonged to a national hero or someone like that, and it found itself in a certain amount of disrepair, almost bordering on derelict. How do we strike the balance between demolishing from your end and putting forward maybe another proposal as to how to deal with it?
From our end, anytime during the process, the owner of the building has the opportunity to remedy the situation. Once the person remedies the situation, we will no longer take action. So in the case of a historic building, once that happens, we no longer will take action. Well, regardless of the situation, once the owner remedies the situation, we will not take action.
So in remedying, one may feel that if the person fixes it, but if the person can show you that there is a plan in place to get it done and can prove to you that maybe it's going to happen over 2 years, a year, 3 months, whatever, that would be acceptable to you?
Usually, if the building is one that we have served a notice on, there are certain things the owner would have to do immediately. If it is overgrown, if it needs some repairs to stop vermin from coming into the building, not that you necessarily have to renovate it and make it new, is just to address the situation where it poses a public health risk. So once you address that, even if you have not renovated the building, even if you're not able to occupy the building, it is really about preventing the public health risk. And once you mitigate that, we will take that building off the list.
Thank you very much, Ms. Henhouse. And now we'll go over to Mr. Cherry. I believe you are ready, sir? Ladies and gentlemen, under these circumstances, I'm going to ask that we suspend for 10 minutes to give them a chance to see if we can rectify whatever technical problems we are having. So if we are in agreement, please say aye. All right, thank you. Yes. But I need to have the motion from someone first. Ms. Ford? And seconded by? Thank you very much. All right, we are suspended for 10 minutes. Thank you.
Testing, 1, 2, 1, 2.
Ladies and gentlemen, just for the record, we've been informed that Mr. Cherry was having internet difficulties, which is beyond any of our control in terms of that. But we still have not heard from any of the other representatives of the V.S. Haulers Association who are supposed to be online or actually coming here physically to be with us. We're going to hold on until our clerk, Ms. Gibson, comes back in, and I think we have to make a decision to either move on if the person coming gets here to meet 12 o'clock, or suspend. And that is basically where we're at. So please bear with us. This meeting will be continued and called to order. For those with us online, just to explain the technical problem that was had by Mr. Cherry is really bigger than any of us could deal with. I guess it's from the provider's problem he's having with the internet, and so we apologize for that unfortunate incident. But at this particular point in time, we have Ms. Kay Williams, President of the Barbados Bar Association, and we are going to move on with her. So if we can bring her in, please. And once again, folks, with Ms. Williams coming in for the first time she'll be seeing anyone, please mention name and organization represented. Yeah. Good evening, ma'am. Good afternoon, ma'am. It's still morning. It's still morning. Good morning, ma'am. That's all right. As mentioned before, ladies and gentlemen, this is Ms. Kay Williams, representative of the Barbados Bar Association. And ma'am, I'm going to turn over to you.
Thank you. Good morning, and permit me to begin by thanking you for this opportunity, this honorable chamber for this opportunity to just share a few of our thoughts and comments in respect of the Health Services Amendment Bill and the draft Health Services Regulations. What we seek to do as a bar is that we would circulate the various legislation, bills, etc., and get comments from our members. Some bills elicit more response than others. On this occasion, there was supposed to be a colleague with me, but regrettably they could not join. On this one, because it's an amendment to an existing bill, we had a few comments which we'd be grateful to share our thoughts, and we welcome discussion on those one or two issues that we wish to raise. So I'll begin first of all with a general comment. The first general comment has to do with the jurisdiction. We did make an inquiry at first to ascertain whether the particular amendments, whether there was a particular jurisdiction, because very often as a Commonwealth, part of the nations of Commonwealth, sometimes we look across the Commonwealth and model laws across our brother and sister Commonwealth countries. I was told that no, there wasn't any particular modeling or any particular trend that we were particularly looking at. And one of the reasons, of course, I was going to ask that is because of the references, a reference later that we'll come down to later with respect to the application for exemptions and the fact that exemptions from the penalties and from the administrative fee will be based on hardship. So when we saw that, the reason why we asked whether there was a particular model is that typically, you know, there'll be tribunal decisions, etc., which may define exactly what hardship is and how that is to be applied. But I will come to that in a moment. So that's one of the first things that we were asking. The second general comment is that the Health Services Act, CAP 44, has served us very well. It was first enacted in 1969. And so therefore, it should be about 55 years, if my math serves me correct, that this act has served us. Since then, based on when I checked the current model of the law, and I want at this point also to refer to the Consolidated Index, which you may be aware of, and this resource is produced by the University of the West Indies each year to show the amendments to any one particular bill, one particular piece of legislation. Now, the actual act, based on my very rough estimate, was amended about 14 times over the 55 years, understandably because of the nature of the bill. And the regulations, you see the list of regulations, amendments go on for actually 3 pages with respect to the Health Services Act, the regulations underneath that. Because, of course, you're amending to meet the various health services issues that arise from time to time. By our rough count, the amendments are about 57. Now, which means that almost once a year in its 55-year history, we've had need to go back and amend the regulations. So the recommendation is at this point whether time is ripe for reform for the Health Services Act, whether the Health Services Act, which I said has served us very well. It's amazing that 55 years later it still is relevant. But the question is, does it meet the needs of modern Barbados? Do we need to create a policy paper? Do we need to rethink, relook, reshape in we've gone past the post-colonial phase where we had a lot of law reform, and we have a good history of that kind of law reform, post-colonial law reform, post-independence law reform. And now we are our own, we are a republic, having transitioned from a constitutional monarchy onto a republic status. What does modern Barbados require? So that is just something that we want to throw out there. Given the extensive nature of the various regulations, how would we want to shape it going forward? And how would you want the act to still have force, but still allow the main actors, such as the chief medical officer, the public health officers, to be able consistently to have edicts thrown out there, to which people have to comply, but yet you still have a holistic piece of legislation you can look to. Because, of course, when I sat down to look at the act, because there were so many amendments to the regulations, you have to make sure and double check to see whether the particular iteration that was before you contained all of those 57 amendments. So it was quite a bit of a hoop, but as I said, it's just something to consider at this point in time. Okay. Now, our comments now will, oh yes, and then one other comment, generally, there is one of the amendments refers to the Magistrates Court Act. Magistrates Court and the penalties and the administrative fees will be collected in the Magistrates Court District A. Now, the legislative grounding for that is in the Health Services Act, which is in the same 1969 Act, which indicated that the penalties and I'll just find the section, it was Section 11 subsection 11, so it's 1111. So the original act would have indicated that a debt recoverable and reasonable costs which are due to the Crown, which of course now will be the state, in civil proceedings were to be done, that debt collection was to be done before a magistrate for District A, notwithstanding the amount of such costs exceeding the normal monetary limit of the jurisdiction of a magistrate. Now, in the magistrate's court, as you know, there's a cap, there's a ceiling. That, since the 1969 legislation, that of course has been increased, and in Barbados it's now $10,000. So it means that the framers said, whatever the cap is at magistrate's court level, even if it exceeds it, the jurisdiction to collect the debt is still in magistrate's court. That part we understand, that's fine, because you can sue for wrongful dismissal at common law, notwithstanding the Employment Rights Act, because there's a legislative grounding that allows you to go to the court even if that measure of damages exceeds the cap for the Magistrates Court Act. But when we look at the penalties, and we will come to see how the penalties the administrative fees are also subject to penalties, the question is, do we still want to maintain the jurisdiction in the Magistrates Court? You can, or you may wish to shift to High Court, but we'll look to see whether that, again, are we addressing what the framers intended? Are we addressing a shift, perhaps, in the manner in which you will be bringing such debt recovery actions, etc. And especially since, as we will see, that the debt recovery is now going to be a charge on land. So you may be encountering challenges where before, when this was first framed, it would be a simple fee. It's a fee owed. Now, with this amendment, we're seeking to attach it to land and for it to become one of the first charges onto land. So then now you're touching people's rights, you see? And so therefore you would ask yourself whether you still want to maintain the debt recovery in Magistrates Court or whether you might want to consolidate everything in High Court. Just thoughts. So we turn now to the actual amendments. And I will start first with the proposed amendments. The proposed amendments for the Health Services Act. That is the bill. And just by way of reference, we do note under the amendment for Section 2 that the Relief Board for this act has been defined as the Land Taxation Relief Board established under the Land Tax Act. So therefore, I understand the need for efficiencies. Anyone seeking a relief, because you're going to be attaching potentially attaching the administrative fee and the penalties to land, I understand why you would want to create not a new board, but you'd want to create certain efficiencies and let it all be heard by the Land Taxation Relief Board. So that is noted. So if you're going to be under the Land Relief Board, again, we ask whether the Land Taxation Relief Board, which in its current composition will contain resource persons who are primarily for tax, and we will understand that. All we're asking is when you look to the composition of the Land Tax Relief Board, whether there would be a resource person, a technical person that understands the intricacies of the Health Services Act as well, or whether there's allowance for that. So in other words, if someone appeals to the Relief Board pursuant to an issue under the Health Services Act, they're going to be going to the Land Taxation Relief Board, and And the question is, will there be a resource person who understands the Health Services Act and the provisions of the Health Services Act on the Land Taxation Relief Board? Just to bring a level of equity to the situation, because again, you don't want to open yourself to challenges. As an attorney at law, I might say, well, look, my client is coming dealing with a health services issue, and here I am in front of the tax board. And does the tax board understand what these health services issues were that caused my client to be here or to be fined? So I thought that it might be something that you could consider in order to bring balance on those types of appeals. I can't speak to the tax relief board, land taxation relief board. I can't speak to that. No, I honestly did not look at that composition, but that was raised, and it's just something that perhaps we could look at. Okay, now looking at Amendment 5. Looking at Amendment number 5. Now, under Amendment number 5, we are dealing with what in essence will be sums and debts recoverable pursuant to non-compliance under the Health Services Act. So, you've created a nuisance. Nuisance has been redefined. We'll get to that in the regulations. Vermin, something has escaped from, whether it be a liquid or something from the property, it's causing a problem, a health service problem, and we need that person to comply. And so therefore, Section 5 seeks to bring a number of amendments to Section 11 and 11A. Now, as we said before, 11A gives the health services, the officers, power to take this matter to take the debt recovery to civil proceedings to magistrates court. 11A deals with the notice period. So for example, the original 11A in the Health Services Act talks about the minister executing work on property that has been deemed to be dangerous or in a dangerous state. And having executed those works, and after the expiration of 42 days, that the particular landowner can, if they have a grievance, or whatever period that the High Court particularly says, if the landowner has a grievance, they have 42 days to deal with that. Otherwise, the minister may direct that the property be sold by public auction for the recovery of debts due to the Crown in respect of any work so executed. That is the basis of 11A. So what the amendments here are, what they're proposing is that the costs incurred with the execution of work, as well as or the administrative penalties imposed for contravention or failure to comply, can now be charged to the property and added to the land tax imposed under the Land Tax Act. And that is repeated then not only for the charge, but also for the penalties, as we have here. And then it goes on to say, it shall be a debt to the state recoverable in the magistrate's court for District A. And under this section, the owner, property owner, may have a dispute, and they then would appeal to the relief board, which is the tax board. Now, a number of things here, I'm not sure exactly how this will roll out, because, for example, you have a 42-day period from the original Health Services Act. Then you have the possibility of it being attached to the land tax bill, which is fine. But if that penalty, for example, is attached to the land tax bill, it's the beginning of a land tax year. As you know, land tax year runs from from the 1st of April through to March 31st. So if there's a breach in May, that land tax owner may say, I have not been deemed to have notice because I haven't seen my land tax bill. Mind you, it may be on the record, but that land tax bill is not going to come out until months later. But you have a 42-day period after which the minister has deemed that work has to be done, because this is a danger and it cannot continue, that they can direct it be sold by public auction. So if you're going to sell it by public auction, and we're going to come to the manner in which the appeals are made to High Court, the debt recovery is allowed in Magistrates Court, and then you have public auction. So I'm just wondering whether this is the most, whether it's efficient or whether you are really putting yourselves in 3 different jurisdictions at one time over one property, because you have public auction one side. Who does the public auction? You're recovering in Magistrates Court, District A, and yet the property owner will be running to High Court for relief or for an appeal from any decision of the relief board. Now, this brings us then to another issue that we want to say here. The question is, are we fostering compliance or are we seeking to be punitive? What is the policy position under the amendment? Just asking that question. I don't expect that answer today, but what I'm saying is, if we're fostering compliance, when it was written in 1969, may have been a different viewpoint. We are in Barbados 2024. Is it that we wish to have 2, 3 strikes, you're out, in the sense that we have a first notice, a second notice, and thereafter the draconian penalty is imposed and or the public auction, meaning that the average landowner, property owner, has an opportunity to remedy. We're asking, can you give the average landowner an opportunity to remedy? I'm sure that there are means, but in terms of the strict legislation, it actually tends to just go towards notice, fine, public auction. It doesn't seem to have layers. But the question is, again, we are the framers of the legislation that governs us. And what is it that we seek to do for us as a people? So one of the proposals would be whether there could be an accelerated or a series of steps that can be clearly placed in the legislation. On one hand, yes, the minister responsible must act and must act quickly, but on the other hand, is it that we are trying to encourage the property owner to be compliant? And if so, how would we do that? And so therefore, so that's why I was saying you might want to consolidate all the actions in High Court, or you might be quite happy to leave the debt recovery in Magistrates Court, but leave the appeals to the High Court. Again, it all depends on what the policy position would be for this particular this particular amendment. So, and in respect of that then, I believe there's another, yes, is there room for second notices, first and second notices? And what allowances are made for the property owner who attempts to rectify and is hampered by the lack of resources or hampered by technical challenges? Now, the backdrop against which I speak is that as attorneys, we tend to find that properties that tend to be derelict, often it's either a situation where all of the immediate owners are either deceased, they all reside overseas, or the property is in dispute. And regrettably, then you find that the particular piece of property which granny left, granddad left, the family home, falls into dereliction and decay. And nobody can agree. There were 14 siblings, and nobody can agree as to what we're going to be doing about it. And nobody wants to be the one to put forward their funds to get it done, because they think, if I do that, that's a detriment to me, I'm not going to get it back. So the other issue we will have is the question of jurisdiction. Naturally, the land is here in Barbados. And thought has to be given when it comes to these notices and issuing and putting it on the land tax bill. Obviously, if someone is paying that land tax bill, that is the trigger to see that something has occurred, and therefore they would want to clear that debt from the land tax bill. I understand that. But in doing so, remember that you're deemed to have served persons with notices, and you may find that those who are out of the jurisdiction will say, but look, the land tax bill says in care of, and it has a New York address. You know I'm not in Barbados, so how did you serve that notice on me? How? Yes, it's in respect to my property, but I'm not there. So we will have to look at jurisdiction as well, and then we have to look at how are we dealing with those persons who are incapacitated, elderly, have lost mental competence, etc. They're sitting in dereliction, the neighbors are complaining. And to add to that hardship, to add to that situation, now the government comes and imposes a penalty. So in other words, how are we going to treat our own citizens who may not even have the wherewithal to know that there's a relief board on which now I can apply, and I have to apply within 14 days for hardship. So what if the 14 days expires? I could barely get myself up for a shower. How am I going to get to the relief board in 14 days? So these are things that I do want to be able to bring to light, because these are the sort of responses that you're likely to encounter when this is brought into law. And in respect of the time frame, that is why when it comes to 6, the appeal to the work done by the minister is within 42 days, which we accept and understand the 42 days. But it says in the amendment that the owner or occupier of the property upon which an administrative penalty is imposed, and I'll just flip over, may appeal to the relief board within 14 days. And we respectfully would ask for an increase of those 14 days. 14 days is a very, very short time for an average person. They get a notice and they're trying to figure out what they're to do with it. Now, we're asking for that to be increased to 28 days, because typically a person, the owner or the occupier, remember it says owner or occupier. So I may be the occupier, but I'm not the owner. I get the property, I'm renting it. I'm renting for somebody who's overseas. I rent it from an elderly lady. She's not living here. I gotta get hold of the cousin down the road to get a message to her. So I believe that we need to give them we need to give ordinary citizens a bit more time than 14 days. I understand that in other statutes we have 14 days. For example, the FTC, Fair Trade Commission, a lot of their timelines are 14 days. But remember, we're dealing with business efficacy there. And very often when you're dealing with matters before the Fair Trade Commission, those persons that already have access to attorneys at law, technical people. So when the appeal time is given as 14 days, it's important for businesses not to be held for too long, not knowing what the situation is. So 14 days is tough, but it's doable for them. But for the average citizen, 14 days is hard. And we do ask for an enlargement of time with respect to that. So that gets us, those are the comments on the act itself. And so therefore, we just have two comments with respect to the schedule. With respect to the schedule, the first comment is the schedule, which is the regulations. The first comment, general nuisances. Yes, the schedule is very specific, well done. It enunciates exactly what is under the regulation, what is a nuisance. And these are deemed to be nuisances, and it's quite an exhaustive list. We would suggest that there still be some form of discretion which would capture a term which perhaps we have not yet contemplated, because, as you know, when it comes to health challenges or health nuisances or health occurrences, you can sit in one decade and something can arise that we have never contemplated. So in 2010, we never thought that there's something called COVID-19. So therefore, there has to be a catch-all phrase that would allow, we believe that in its specificity, you have to still be able to have a catch-all phrase that allows a discretion to determine a nuisance. And by that, what do I mean? For example, let's just take 1A. A nuisance is any place, matter, thing, deposit, or accumulation of liquid or solid matter. So, for example, it says place, matter, or thing. Does that mean that it includes, for example, gases? Does that include, for example, some high-tech thing that gives off a radio frequency or a radio emission that then annoys the neighbors? So you can't ever define based on today's context. There always, once the section is finished, then there has to be a discretion in case we have to contemplate a technology, a health challenge that was not contemplated when it was framed, so that so that you still have and can still keep the amendments are still relevant. But again, I don't know whether that can be said to be so, because when we look at the number of amendments, you realize that that is precisely why there's so many amendments, because you cannot contemplate all of the scenarios. And from year to year, from decade to decade, we've had to come back to this legislation time and time again. So then we turn to the application for exemption. And as I had indicated to you, in section 5, I will read, we have, of course, in section 5.1.2, an owner or occupier may be exempted on grounds of hardship. Now, how is that hardship applied? How is that hardship defined? We don't know. We would have to turn to tax appeals, because of course the relief board is a tax board. And so therefore, if that person applies on the ground of hardship, we just wondered whether, let's see, in terms of the timelines, the timelines for the appeal to the relief board will be set out by the legislation. So again, the question is whether the relief board would have the discretion, if someone who is truly experiencing hardship, trust me, it's hard to even get to the point of appeal. But even when you get to the point of appeal, you're told, whoops, your 14 days are gone, your 28 days are gone. Is there any discretion in a true case of hardship that someone can come and it allows a discretion on the very basis of hardship for someone who may be out of time? Just putting that out there. And And then our next comment is respect to the appeals, 10.8, which is the last section under appeals. Under 10.8, a person aggrieved by the decision of the Relief Board may, within 14 days of the receipt of that decision, appeal to the High Court. Now, in our view, again, we once again appeal on that time frame. For the ordinary citizen, 14 days is very short. You would have just gotten a decision from the Relief Board. They're told you have to pay, or you're told that your property may be sold, and you have to figure out what you're going to do. And you have 14 days to figure that out, determine what your next step may be. And if you're going to be appealing to the High Court, the likelihood is that you have to then retain an attorney at law. And you have to get that appeal in 14 days. We would respectfully ask for the time frame to be 28 days. Why? Because when you look at the Civil Procedure Court rules, rule number 65 generally provides that any appeal from any tribunal, appeals from tribunals, typically you have 28 days. And just for consistency, tidiness, I think it would be good if the time limited for appeals in the amendment to the Health Services Act is also similar to the time limited for appeals under the civil procedure rules. So it says here, the appeals to the High Court, Part 60. This part applies or deals with appeals to the High Court from any tribunal or any person under any enactment other than appeal by way of case stated. Now, of course, if an enactment has its own rules, you have to, of course, turn to the rules for that enactment. But just understand that we believe that the time frame of 14 days to that property owner who has just been told by the Tax Relief Board that regrettably no, and they now have to figure out their next steps. We are asking for 28 days instead of 14 days for them to figure out their next steps, to retain counsel, and to still be within time if they are seeking to take it to the next level. And I believe that the 28 days shouldn't in any way significantly prejudice either the state or the party bringing. Now, there's one other note I wanted to make was I wasn't clear on how the penalties would be calculated. The penalties, it indicated here, if I could go back, that the administrative, there's a schedule in the first and second schedule. The administrative penalty is not that high, it's $300. But we notice that there is a penalty for continuing contravention, which is $10 per day. And when you consider that you have an administrative penalty of $300, and then for every day that you continue to be in contravention, $10 per day, and then you bear in mind that this penalty, the actual administrative fine plus the penalty, will be added to the land tax bill, and the land tax bill itself is now subject, as you know, there's an interest and penalties for every period that the land tax bill is not paid. So I don't know whether that is an accumulated tax, compounded, whether it's separate, but we want to make sure, again, And again, our heart goes out to the elderly, the incapacitated, and those who are suffering perhaps with dementia and fuddling through and don't quite have the support. They could be in contravention for years, literally. Is there a cap, for example, in corporate affairs department, there are penalties, per day penalties. But after coming to the corporate affairs department and making certain representations, they agreed that there will be a cap. So in other words, there's a cap which does not exceed, I believe, 3,000 something per year. So therefore, the penalty is $10 per day, but with a cap of X amount per year for every year that you have not complied. At least if someone is regrettably in a position either for technical reasons, resource reasons, or otherwise, you know that if you've been in contravention 2 years, at least it would not exceed a certain cap, because the idea, I would think, is to foster compliance, not necessarily to disenfranchise simple persons from property. So I would ask whether we would consider that. We also want to consider that the penalties not be compounded unnecessarily, because if it is an estate, so for example, there are difficulties with getting the estates done, there are delays in getting the estate sorted so that we could pay out the beneficiaries or sell it, and so on. But then by the time we get to selling the property, to divide it up among the beneficiaries between the tax and interest and penalties, and then it may have been in bush, so therefore, by the time you're done, you wonder whether there's anything left for a beneficiary out of the estate. So we want the penalties, because it is clear that Barbadians need to be responsible. That Barbadians can't just be looking after properties and not play their role. But on the other hand, we don't wish necessarily, I would think, we don't want necessarily to disenfranchise or to make the taxes so onerous that they will have to sell just to pay the taxes. That is in addition to all the other obligations that they would have as a property owner. And I think that then brings our comments as a bar. That would bring our comments to a close at this point. I don't know whether you have any questions, but those are our observations in respect of the bill and the regulations. Thank you.
And thank you very much. There's a lot for us to think about. And I'm sure that everyone at the table has been listening attentively. So I'm going to open the floor now for any questions that you may have for the representative from the Bar Association.
Good afternoon. My name is Ronald Chapman, the Acting Chief Environmental Health Officer, Ministry of Health and Wellness. I really appreciate the presentation and the points that you made. I do not have questions as such, but I would like to address a couple of the issues that you mentioned. With respect to, I'm going to start from the bottom and come up, with respect to old age persons, persons who are indigent and so on. There's a facility there within the Ministry of Health and Wellness, within the Inspectorate, where we consider those persons. If we find persons in those conditions, we do not generally serve notice on them. Those persons are referred to the medical officers of health, who then go ahead to provide the necessary social services for their upkeep. So you will not find, generally, you will not find persons who are the really old age pensioners and persons who are injured and so on getting notices. In fact, the Ministry of Health also has a labor force which is there, that is assigned to those persons to actually clean around their houses and for their upkeep. And my minister here will tell you that he is quite happy to have recommended an increase in the amount of laborers that we have. So we're working on that. So there's the welfare office that we refer them to. Sometimes we have to refer them to the geriatric hospital or the other agencies. So there is that mechanism there for them. In terms of the number of days with which persons have to remedy a nuisance, there are, strictly legally speaking, your points, I take them, I think they're very valid. However, I think that we need to also look not only at the overgrown vegetation, but the nuisances also speak to the breeding of flies, mosquitoes, and other vermin. The average mosquito takes, Aedes aegypti mosquito takes 7 to 14 days in which to breed. A fly is 3 to 5 days. And if we leave those conditions unattended for 28 days, for 48 days, and for another 14 days, depending on however we put that, you can see how a neighborhood can be inundated and the spread of disease. The Ministry of the Health Services regulation is there to prevent the spread of environmentally driven health hazards or diseases. So there must be some sort of balance between the amount of time that it takes for that environmental health risk to be generated and the time of remedying that. And sometimes what we have found in the past is that you give some person some time, because what happens normally, the health inspectors will give some person some time, and it's usually done verbally first. And then when they come back, it's not done. Then you serve a notice according to law. Now, that is not necessarily the way the legislation is written. The legislation basically says that from the time you give that instruction has to be in writing. But for the purpose of business and to make things easy, sometimes you tell a person, hey, go ahead and take care of it, because if I come back and go, I'll do something with you. And they usually comply, but sometimes you don't. So the second and third notice sometimes will take you well beyond what is environmentally safe in terms of preventing a nuisance or causing a further problem. Because if you have a person with a 55-gallon drum or maybe an underground tank, and they're providing mosquitoes for a whole neighborhood, you are going to have dengue fever or whatever else spreading in that period of time. The last thing I want to mention, in terms of serving the notices on persons overseas, when we serve notices on, we usually like to get those notices registered and sent out. A lot of the times we get movement, sometimes we get no movement, and as you would appreciate, as you said, sometimes the house is in dispute, there's under distress, whatever case may be, and you have those issues. Persons overseas, Daddy may leave you a piece of property. You only have no intentions of coming back to Barbados, and the property is there. Normally, when those persons are contacted, as I said, you get some movement. I honestly believe that the attachment of this onto land tax will sometimes drive that movement forward, because it is very, very difficult, as you could appreciate, to overstretch into another jurisdiction to get persons to come back home and claim a piece of property, especially if they're overseas struggling and sometimes they don't even know they got the property or what the property is worth, or they have no intentions of coming back to Barbados. So there are iterations of the legislation that, strictly speaking by law, as you had mentioned, there are issues that are relevant, but presently, we work within the legislation and the other structures to address those areas. The last thing I want to mention in terms of the continuing penalty, the present legislation that has not yet been amended allows for $200 per day. And this is now as opposed to $10 per day, which is, this is recommending, but that is determined by the magistrate, within the magistrate's court. And that is usually after the person has, I think in this case, the question then is, after the person has exceeded all appeals, when does that start and so on? And that is, I believe, something that I will be guided on where that is concerned, but presently it is $200 per day as opposed to 10, and that is levied within the magistrate court. Thank you.
Thank you, Mr. Chapman. The floor is open for any other questions. CPC, hopefully.
Good afternoon, Shaquille Newton, Parliamentary Counsel acting from the Office of the Chief Parliamentary Counsel. I noted your comment about the catch-all provision for the general nuisances, and I just wanted to draw your attention to Regulation 3 of the draft Health Services Nuisances Regulations. And when Regulation 3.1a and 3.1b are read in conjunction together, it does have the effect of catering to almost every imaginable situation which could constitute a nuisance. So that in and of itself can be used as a catch-all provision within the legislation. I also noted your comments about the multiple amendments to the Health Services Act. I believe you're referring to the multiple health services regulations, and that—
Sorry, I did make that distinction. Most of the amendments were to the regulations and not to the act.
Yes, and that is normal in the course of things for a matter such as this. If you look at the principal legislation, the Health Services Act, Chapter 44, you will see that under the enabling provision, Section 10 of the Principal Act, that there are paragraphs A to Z, which enables the minister to make regulations, but subject to negative resolution. And these paragraphs A to Z cater to a whole variety of situations which the minister can make regulations for. And in the normal course of things, regulations are used to flesh out the principal legislation, to add the matters of detail, which can all be added within the principal legislation. So this is quite normal, and in the context of public health and a fluid situation, one would expect to find a lot of regulations.
Thank you. Any response, ma'am?
Yes, with respect, I'll start with CPC, my colleague from CPC first, and then my colleague from the environmental. Yes, I agree that I would expect that when it comes to public health, we're always having to respond. The only question, the wider question I asked was, given the age of the legislation, and I kept saying it serves us very well and continues to serve us very well, whether the time is ripe for any form of reform or a policy paper as to how we are going to take ourselves into the next 50 years. It served us well for the past 55, and the question is, do we need to relook it? Does Republic Barbados, do we now need to look at it again for the next 50 years? If it's fine and the vehicle is fine and doesn't need further further thinking through, that's fine too. But the question is, ought we not at least address our minds to that exercise to see whether the vehicle works well for us today? That's one. Two, so thank you. I understand with respect to my colleague from the environmental, these are environmental services, that yes, I understand what you're saying in terms of public health and nuisances, and the fact that very often you may not have a lot of time. So the balance has to be there. The balance has to be there where the message has to go out to Barbados that we have to take this very seriously. Barbadians are house proud, we know that, and we're very home proud. And the question is, why then are there so many areas which are derelict that we do not attach the same level of pride to? And so therefore, once we get to the bottom of that, we have to realize that we have to pull everybody up. And that for the ordinary Barbadian, they have to recognize that if there's a piece of property, family land, etc., that with every right, which is your right to ownership, comes a responsibility, and that responsibility now is one, is a matter of public health, which concerns us all. So the right to ownership comes with responsibilities, and the responsibilities have, regrettably, a price tag attached to them, and we have to get that message out that as Barbadians, that we have to take that even more seriously than we are taking now. Not only where we just live, but the other properties for which we may have to be looking after for family members, etc. With respect to the welfare, I'm very glad to hear that. And I just wonder, it's not encoded, regrettably, in the legislation for references or a reference to the welfare department for those who are indigent, for those who are struggling. So I don't know whether we would want to. Again, it all depends on the policy underpinning for this particular piece of legislation and for the amendment in general, whether we want to balance the social services against that responsibility, that price tag that comes with the right of ownership of property. And is that something that perhaps is in the next iteration of the, of the health services bill for another 50 years, balancing the social services and taking care of our people against our people stepping up to their responsibility when it comes to property ownership. So thank you, I appreciate that.
Thank you very much, Ms. Williams. I want to go online to Ms. Tony Moore, who has a question.
I want to, mine is more comment, and I want to say a very special thanks to the bar and as well to Mr. Chapman for the comments and responses that have been forthcoming. Because the question that I really had was responded to in large part by the bar in its response just now, because the concern repeatedly through the comments from the bar is how do we strike the balance? How do we address whether we are trying to curb behaviors or whether we are trying to be punitive? And depending on how you look at the legislation, it may appear to be one or the other, but I think that in responding to the welfare components to a very large extent, Mr. Chapman addressed the issue of how we care for our people, something that I would think we have to be very careful how we try to encode what should be a policy position into law, because there are so many factors that can be considered. One of the things that we find very often is that elderly people, let's take elderly people for instance, they have no support, they need welfare assistance, that person dies, and so many different people are coming forward to claim what they have not been contributing to. So I think that policy positions should remain to a very large extent that, and we should be very careful about how we put them into law. But one thing that CPC Shaquille, Mr. Newton mentioned in his response regarding the catch-all phrase that can be provided is that when you read one part in conjunction with another part, it provides the catch-all. And I think that one of the things we should want to do is simplify legislation. People may not even read legislation, but if there's going to be any reference, you go to the law and regulations, except for you attorneys and so will seldom be picked up by regular people. So if we can simplify the language within the legislation to address the catch-all provision that the bar has called for, I think that it will be useful. And the other important takeaway that we have coming out of this discussion, I think was captured so beautifully by the bar just now. With the right to ownership comes responsibility. And in order for Barbadians to take this seriously, I think that it is emphasis on something we've said at our last meeting, at our initial meeting when we were contemplating these particular amendments, is that we really have to do a PR campaign. We had growing up, I know there was a cleanup campaign, you had the tourism campaigns, but we have to teach people responsibility is not only the house that you live in, but it's the property you own that you don't yet live in. And maybe you don't currently have the wherewithal to expand it, but the reality is it is yours. And very often, and I don't feel a way about repeating it, very often when people don't clean up around them, it becomes somebody else's responsibility. And I say this as a person who said before, lived between two open lots. I had the responsibility for my safety and my security to be maintaining those lots. So in striking the balance, we also have to be very attentive, not only to the welfare and the hardship of those who are owners, but the welfare and hardship of those who are not owners, but who also have responsibility. I welcome the comments, some of the comments about the 14-day period versus the 28-day period. And of course, that has to be taken in line with the very useful comments that came from Mr. Chapman as it relates to public health risks and how we balance those. But so I think that in light of the comments, environment can go back. And I think that this exchange has been really useful, can go back and examine further, because I know it has been at the heart of their consideration in having these amendments proposed, can go back to see where we can give more in terms of striking the balance, bearing in mind not only those people who may have the penalties applied to them, but also the people who are being compromised by their properties not getting the kind of attention that they should give. So the issue of balance and public relations are the two big takeaways that I think will inform our consideration as we try to report back and see if we can make any improvements to these amendments. So I thank you all.
And thank you very much. Are there any other questions or comments from members of the committee? Mr. Chapman?
Yes, please, just one more comment, two. In terms of, I think, in terms of policy and law, in terms of, when I talk about policy, I'm talking about health policy. Within the Ministry of Health, we talk about health promotion. And one of the tenets of health promotion is behavior modification and the empowerment of persons to take responsibility for their own surroundings. That has to do with capacity building, skill building, all sorts of stuff like that. And we try to use both the health promotion aspect to move persons along, which is more the carrot sort of concept. And then it has to be backed up by the legislation, because as you would all appreciate, there are persons, and the vast majority of persons, I might say, will move along with just the carrot. And then there are the odd few that it may seem punitive in the legislation, but the fact of the matter is, there are those that no matter how persuasive you are or how gentle you are, they will not move until they are faced with the law. And I've seen this, even those who have been faced with the law, because only a couple days ago, I was in a law court. We had a guy, he got charged. He pled guilty, I should say. He had derelict vehicles on one side of the road on someone's property. He was instructed to move them by the court. He moved them from one side of the road to the next. So it's those sort of persons you have to deal with. And finally, I would like to say thank you very much for your first comment in terms of the amendments to the regulations and so on, and to the Act, because you will see even more amendments, or should I say, more applications for amendments, because the Health Services Act is, health, I should say, is living and breathing. And because of that, the Act has to change. And there are a number of areas presently that we have no legislation to govern. I'll just give you an example. Things like tattooing. There is no legislation anywhere in the Health Services Act that governs tattoo artists, and you could appreciate the health risk in someone who is a charlatan doing tattooing. Fortunately, we have not come across any tattooers who have not availed themselves of additional training in terms of health and so on, but that is the individual, but that doesn't mean that there isn't someone out there. So you understand? And then there are a number of other things. So I really appreciate the plug for the health services amendments, and I look forward to, as we go forward, we continue to make those amendments to strengthen the Act and strengthen the regulations so that we can serve Barbadians better. Thank you.
Thank you very much. I just have one query also myself. When we looked at the general nuisances and you wanted a definition, or my understanding was further definitions in it. I wanted to find out from you, from a legal perspective, when you look at the word thing, what does that cover? The word thing.
Thing?
Yes.
That's the point. We as attorneys, vagueness is something that only spawns further debate. And so therefore, thing is something that will likely spawn further debate. The question is, of course, typically, when you look at any piece of regulation and you see something that is relatively vague, as attorneys at law at the private bar, the first thing we do is that we look to precedent. So we'd be looking, for example, to a jurisdiction within the Commonwealth that may have a similar piece of legislation, and see how the courts or the tribunals have interpreted that particular word. So that's why I asked, does it include gases? So I built up some sort of gas. Does gas fall under matter, thing, deposit or accumulation of liquid or solid matter? Does it include a frequency which annoys or upsets the neighbors? Would that fall under thing? So typically in order to answer you, when we look to define something that, a word that in its common sense or ordinary meaning may not necessarily assist us if we were bringing something under the Act, then we look to how it is interpreted. So again, that's why we asked whether in drafting, whether there was a particular jurisdiction or something that we were looking at so we could better understand the words. I do know that thing probably is part of what they wanted to do in order to be able to not be limited. Because if I find something that doesn't otherwise fall under, I should be able still to exercise that authority. But yes, when it comes to thing, that's a word that's very wide, and I believe the wideness, the vagueness of it was on purpose. But we attorneys will look to legislation to see how that would be likely interpreted.
Thank you very much. CPC, you want to add to that?
Good afternoon again. Yes, agreed, and yes, thing was included so that it would be sufficiently wide to capture a variety of situations and matters. Yes.
Thank you very much. Ladies and gentlemen, if there are no further questions, comments, I would like to thank all of you for joining us this afternoon. Your contributions are invaluable, and we look forward and we hope that if anything else arises as we go through this process, that we can contact you, ma'am, for any further help that we may need.
Certainly.
Thank you very much. I'm going to ask you to, if you can, hold on. We are inviting you to lunch with us this afternoon. And so, again, on behalf of the chair, who is outside of the island at the moment, but with us online, and the entire committee, thank you so very much for being with us this afternoon. Thank you.
Thank you, Chair, and thank you again for this opportunity on behalf of the Barbados Bar Association.
Yes, ma'am.
Am I invited to lunch as well, Chair?
Yes, ma'am. When I chew, you swallow.
Okay. Just for clarity, we are not resuming. Is there any plan to bring in Mr. Cherry after lunch, or should we stay tuned?
Stay tuned, because the difficulties, as I mentioned earlier, that he was having was with the internet service in his area. And so we would need to find out from him where he's at, and we haven't had that information as yet.
If it can be resolved today, so I will listen out for a message from you, Beverly.
Good, thank you.
Thanks, everybody. I'll leave for now.
Good afternoon, ma'am. Good afternoon. So I'm going to ask the committee if we can have a motion moved to have the minutes that were deferred to, that they should be deferred to the next meeting, which will be next Thursday. Okay. Motion by Senator Rogers, seconded by Minister Ford. Thank you. And we go now into any other business. And so for those persons, if there's any other matters which we need to raise at this point, Honorable Trevor Prescott, if there's anything, this is the opportunity to do so.
Thank you, Mr. Chair. Yes, sir. No, thanks very much. I believe it is best for me to, any comments which I would like to make or queries, when we meet on the next occasion, and make sure I put them on the table. So thanks in general.